You won't believe the chaos in this courtroom. Miss Malik, a squatter with a reputation for causing disruption, is back at it, this time challenging an eviction order. From the moment the hearing begins, she repeatedly interrupts the judge and the opposing lawyer, claiming she's been swindled and treated unfairly. Her arguments are dramatic, her interruptions relentless, and her logic, let's just say it's something else. The landlord's lawyer explains that Miss Malik is a month-to-month tenant who skipped her court date, leading to a default judgment and a writ of eviction. But that's not all, she's left over 120 voicemails, some threatening the lawyer, his family, and his office staff. The tension is real, and the courtroom feels like a pressure cooker ready to explode. Judge Simpson lays down the law, denying her motion to set aside the judgment, and clarifying that she must vacate the property by January 16. The judge also addresses the escrow money, explaining that it will be held for 15 days before being returned to the defendant, not the plaintiff. Even when she tries to bend the rules about the escrow address, the court keeps a firm hand. This hearing is a wild ride, showing exactly how complicated and frustrating dealing with entitled tenants can get. From threats to constant interruptions, it's a dramatic showdown that you have to see to believe.
And I can receive from you today, sir. I have been in a very horrible, assaultive position.
Okay, hold on a second.
Okay.
State your name for the record.
Danette Malik.
Okay, go ahead, Ms. Malik.
Well, I entered your courtroom honorably last year at this time. I came in as a plaintiff.
Okay.
And when I swore in, I gave some information about one company, Akram Rashid, merging with a new owner. At that time, I, the customer, was not given the respect, nor any other tenant in my building, underneath the laws to meet this person as a consumer. It is of complete responsibility for a new company to acquire the permission of the tenant, where money is concerned, to enter a good consumer relationship. This did not happen. Time proceeded, and this maintenance company decided to enter person's property with no permission, started to manipulate them, stealing possessions, stealing automobiles.
Okay, ma'am, can I ask you something?
Sure.
Is this your motion to set aside the judgment?
Well, I did set it aside, and we met that agreement. An attorney named Kevin Callahan sat in a court with me as a plaintiff. According to the law, there are no attorneys allowed. So I tried to motion in at the end of August because I recognized—
hold on, no attorneys allowed where?
When I first met with you, Your Honor, I went into a small claims, and I was underneath the impression through the courses of the law that there were no attorneys allowed in a small claim. So something kind of got jangled up. I presented charges.
Ma'am, hold on.
Okay.
Okay, because I want to make sure that I've got everything in front of me. Was there a small claims case?
Yes. And at that time, we made an agreement.
Go ahead.
That after August, which was Akram Rashid's current lease, that there were not supposed to be any changes to, yet that wasn't the case. I would be on a month to month. I raised my right hand. Kevin Callahan, yourself, and I made that agreement. He swore to me, my mother, which then reported it to my banks. I reported it to my private attorneys in New York City that managed my work. And I contacted the courts. I talked to him verbally over the phone from his office in St. Clair Shores. And he stated to me that I swear, you're going to receive that sheet of paper. I waited, and I waited, and I waited. Spring and summer came to fruition, and I called the courts. It's getting, later in the year. Where's the sheet of paper? It was as easy as that. There was no failure of me to make the payment. I still have the finances set aside. I feel like they are trying to retaliate against me because I've continued to make reports. My sole discretion, I have the right to do that. Between the Michigan State Police that were called on numerous occasions by other.
Ma'am, I'm going to have to stop you because I'm not clear what you're talking.
Well, I think that there's a position here where there's charges that he wanted to dismiss, but because he did not fulfill the obligation that he promised me, by August, I was being manipulated and they're not following through with the original agreement.
By whom?
I, yourself, and Callahan last January coming into February. We sat in the Zoom conference. I presented the paperwork that was unorthodox.
Judge, if I may, I have information
owner.
on this. I can.
And this change of ownership will not affect your lease agreement. She put unless otherwise indicated in your current signed lease. Well, unless otherwise means I can't do what I'm claiming I'm going to do. She broke these laws.
She being whom?
E.J. Elizabeth Jefferson, who claimed to be a property manager that no one had ever met. There is no legible address. The Attorney General states that she's not a registered or licensed person. The federal offices told me not to be in business with them.
Ma'am.
Yep.
I'm going to tell you right now, you've lost me.
From the very beginning, I presented the first time I came in to see you. I presented both pieces of paper.
Stop for a moment.
Okay.
I had them pull a small claims case involving yourself against Bell Management.
Yeah, they did things that were illegal. Fair housing.
Ma'am, that was over a year ago. I would like to say I absolutely remember that.
Yeah.
But I don't.
I'm in dismay myself, sir, because I made that agreement with you. I clearly don't allow a judge or myself to be taken advantage of by an attorney's office.
Well, I don't know that I've been taken advantage of.
I believe I have been.
Okay.
I would not enter your courts to present this witness information as very
Ma'am, stop for one moment. Okay. Let me hear, I've heard from you for a while. Let me hear from the other side.
Okay.
Mr. Callahan.
Thank you, Judge. Kevin Callahan, P78273, representing Bell Asset Management. The matter that Ms. Malik is speaking of was a previous matter, a small claims matter that was filed against my client in conjunction with a non-payment of rent matter that we filed against Ms. Malik. Those matters have been decided. Those matters are closed. It has no bearing on this matter whatsoever. This current case, Ms. Malik even admitted she's on a month-to-month tenancy. We provided a 30-day notice to Ms. Malik. She never showed up to court, so a default judgment was entered back in October against Ms. Malik. We subsequently filed a writ of eviction. That writ was signed by Your Honor, and now we get this motion to set aside that default 2 months after the default was entered, alleging that no attorney present and it was against her rights. And I'm as lost as you are with this, Judge. There's no basis to set this judgment aside. Ms. Malik is a month-to-month tenant. She has to vacate the property. However, I will say for the record, because I'm not going to let my reputation possibly be besmirched on the record here of doing anything illegal or improper, Ms. Malik has called my office and left over 120 voicemails accusing me of crimes under the federal law that don't exist. Made threats against me, my family. Miss Malik, I allowed you to speak. Please allow me to speak. She's made threats against my bar license. She's made threats against my family. She's made threats against my office staff. It has been deplorable what my staff has gone through with Miss Malik over a situation that is a simple month-to-month termination, and Miss Malik refuses to leave the property.
You won't believe the chaos that unfolded in this courtroom. From the very start, Miss Malik, a squatter with a reputation for entitlement and disruption, dominated the room with her relentless interruptions and outlandish claims. She arrived with a bold attitude, immediately challenging the eviction order against her. Every word she spoke was laced with indignation, insisting that she had been manipulated, swindled, and treated unfairly. The courtroom quickly became a stage for her dramatic arguments, and the tension was palpable. She interrupted the judge, spoke over the opposing lawyer, and made claims that seemed almost impossible to believe. Each outburst was more exaggerated than the last, drawing shocked looks from everyone present. She insisted that her rights were being ignored and that the law itself was against her. Every attempt to redirect the proceedings was met with protest and theatrics, making it clear that this would not be a simple hearing. Miss Malik's history in this case adds more context to her actions. She is a month-to-month tenant who failed to appear at her previous court hearing. That failure triggered a default judgment in favor of the landlord, along with a writ of eviction. The landlord's attorney, Mr. Callahan, explained the situation in precise detail, highlighting that Miss Malik had already had the opportunity to present her case but chose not to. He also revealed a staggering fact: she had left over 120 voicemails, some of which contained threats not only to him but also to his family and office staff. The sheer scale of her harassment stunned everyone in the courtroom. What might have started as a standard eviction hearing had escalated into a tense, high-stakes confrontation, revealing the full extent of the nightmare that the landlord and legal team had been facing. Throughout the hearing, Miss Malik refused to remain silent or follow courtroom protocol. She repeatedly interrupted the proceedings, offering dramatic explanations for why she believed she was being wronged. She attempted to justify her behavior by claiming that her tenant rights were being weaponized against her, though the logic of her arguments often left the room in disbelief. The judge maintained patience and control, calmly reiterating the legal facts and reminding her that personal grievances did not alter the law. Despite the judge's composure, Miss Malik's constant disruptions made it increasingly difficult to maintain order. Each new claim she made was met with careful clarification from the judge, who explained that the eviction process was legally sound and that there was no basis for overturning the default judgment. Mr. Callahan, representing the landlord, presented a detailed picture of Miss Malik's behavior. He outlined her repeated failures to comply with court orders, her incessant voicemails, and the threats that had been directed at him and his staff. It became evident that this case was far more than a typical eviction. It was a pattern of harassment, manipulation, and deliberate obstruction. The audience in the courtroom watched as the tension built, recognizing the extraordinary patience required by both the legal team and the presiding judge. Every interruption by Miss Malik, every exaggerated complaint, and every dramatic gesture served to heighten the stakes and keep the courtroom on edge. As the hearing progressed, the judge moved to address the key legal issues at hand. Miss Malik had filed a motion to set aside the judgment, claiming she had been unfairly treated. The judge methodically addressed each argument, pointing out the lack of legal basis for her motion. Despite her persistent insistence that she had been wronged, the court maintained that the eviction order was lawful and would stand. The judge emphasized that while Miss Malik had been given prior opportunities to present her case, she had failed to act in accordance with proper procedures. Even as the courtroom tension reached its peak, the judge's statements were firm, clear, and unyielding. One of the most significant moments of the hearing revolved around the timeline for vacating the property. The judge clarified that the eviction order would not be executed before January 16, effectively giving Miss Malik an additional 10 days to leave. While this might have seemed like a concession, it was firmly within the legal framework and provided a structured timeline for compliance. Miss Malik, however, treated this announcement as if it were a personal affront. She continued to argue, insist, and interrupt, refusing to accept that the court's decisions were final. Her dramatic behavior highlighted a fundamental disconnect between her perception of the law and the legal reality she was facing. The issue of the escrow money added another layer of complexity. The judge explained that the escrow would be held for 15 days before being released back to the defendant, not the plaintiff. When Miss Malik asked if she could provide a new address for the escrow, the judge calmly told her to submit it to the clerk's office. This exchange demonstrated the court's efforts to manage the situation fairly, while simultaneously enforcing the law. Despite the clear instructions and the orderly handling of funds, Miss Malik continued to challenge every detail, attempting to bend the rules to her advantage. The hearing also revealed the personal toll of Miss Malik's behavior. The landlord and his legal team had been subjected to persistent harassment, threats, and disruptions. It became clear that dealing with a tenant like Miss Malik was not just legally challenging, it was emotionally and mentally exhausting. The courtroom audience could sense the strain, and the judge's measured responses provided a counterbalance to the chaos. Every clarification, every ruling, and every statement of fact was delivered with patience, underscoring the professionalism required to handle such a contentious case. Miss Malik's behavior also drew critical attention to a broader issue: the potential for tenants to misuse legal protections. Her attempts to manipulate the legal system and challenge valid court orders illustrate how complex and frustrating eviction cases can become when individuals are determined to push boundaries. The hearing served as a stark reminder that the law exists to protect all parties, but it requires discipline, respect, and adherence to procedures. By the end of the hearing, the legal matters had been clearly resolved. The motion to set aside the judgment was denied, the eviction order stood, and the timeline for vacating the property was established. The escrow money was secured, and instructions for providing a new address were clarified. While Miss Malik continued to express her grievances, the courtroom had maintained order and ensured that the law was upheld. The proceedings highlighted both the challenges of handling entitled and disruptive tenants and the importance of a patient, structured legal process. In the aftermath, it is easy to see why this hearing captured attention. The combination of persistent interruptions, dramatic claims, and the tension between personal perception and legal reality created a courtroom experience that was both chaotic and compelling. It showcased not only the struggles faced by landlords and attorneys but also the resilience and professionalism of the judicial system. Through it all, the judge, the legal team, and even the courtroom audience witnessed a masterclass in managing disruption, upholding the law, and maintaining fairness in the face of relentless challenges.
Judgment to stand and the writ to stand so that my client can move forward.
The property. I never made any threats to anybody's family. I never made any threats to anybody. I did call the office. I asked him for the sheet of paper that he promised. He said he would give me a month to month after August. I said, what is going on? I said, give me the oral confirmation or the written confirmation, and I'm going to continue to pay the money from August onward. I asked your court, I said, may I please have the sheet of paper?
Ma'am.
I did not threaten anybody.
Okay, fine. I don't know anything about that. And I'm not.
If he made an agreement about a month to month, why am I?
Ma'am, you have interrupted me numerous times.
I'm sorry.
That needs to stop.
I did not threaten anybody.
Okay, fine. Always
Just
two sides to the story.
Rude.
But the reality here is you're before the court challenging, you're asking me to set aside a judgment to stay the writ.
She then told me, she flip-flopped with me 3 times. She put another sheet of paper underneath my door, asking me, E.J. Jefferson.
Ma'am,
she
that
asked
has
me if I
never...
abandoned my unit.
Ma'am.
Then she tried to take the money out
Ma'am,
3
okay,
times
ma'am,
in
I'm gonna,
September
you know
and
what I'm gonna do,
October.
ma'am? Here's what I'm gonna do.
But there was no order.
Ma'am,
of payment.
I'm
She-
gonna pass the
She
matter.
asked me to move
Quit
out.
interrupting me.
Yeah, she's still
Quit
trying to take the money.
interrupting me. That's warning 2. On the third one, I act. You're before the court to set aside the writ of, to set aside the judgment and the writ.
Yes.
So that the record is clear, the judgment was entered for failure to appear at 2 hearings. First one being October 6th, and then on October 20th. I issued the, of 2023. I issued the judgment.
Because I thought that the month to month would be honored. That's all. That's all that he gave me. It was all the information I went by, was what I was sworn in. When I'm underneath oath, an agreement is made, nothing happened other than me calling his office and asking for that sheet of paper. I diligently, respectfully, and responsibly, as
Ma'am, you can have a seat before I find, because this is going way far afield. The only issue before me is the order that I issued in October, which was the judgment, and then the writ of eviction.
well, I failed the October. I don't know how. I got confused. I'm not accustomed to the courts.
Ma'am, but if at any given time, here's what the problem for you, Miss Ma'am, and I'm just gonna be blunt about it. That judgment went out from the court shortly after my signing. All right.
Sir, may I ask something of you? Once an agreement is made in court, isn't that you respectfully gave me the month to month. He told me if I dropped the charges on his group, his client would agree to give me a month to month. I mean,
Then you're gonna have to file a new claim that alleges that. That's not before me.
that's why I motioned in August.
No, but that is not before me today.
This is how I will state it.
No,
No,
you
wait.
won't.
I
That's
can,
not before me.
I can pay the money. There was never a failure. I swear, I had the money aside.
They want you out.
I
It's
didn't,
not about the money.
they asked me to pay. There was no probable cause in any level. I called his office respectfully. I asked him for the sheet of paper for the month to month that was agreed upon after August. She put a renewal underneath my door. If she wanted me to leave, why was she sending me a renewal? She tried to take the money out in September and October. That would mean I'm still on a month to month. I just said, where is the paperwork to confirm that? My bank has it on the record, JP Morgan Chase, September and October.
Ma'am, they want you out.
But she asked me to renew.
Ma'am, I don't know about any of those conversations. They have properly been granted a judgment for possession. They properly filed the writ or the order of eviction. I've signed the order of eviction. There is no basis, and I've listened to everything you said to me. There is no basis for this court to set aside that judgment or to stay the execution of the order of eviction or the writ of restitution. There's no legal basis for me.
I can't pay the money that was agreed
They
upon,
don't want the money.
Hmm.
This was
even though
a-
she tried to take it out in September and October.
This is a termination of tenancy case. I don't know anything that they've done regarding taking it out. This is
They did. They
termination.
tried to take the money out.
Okay, ma'am, that's fine. I don't know that. But even if that were true, the judgment in this
What did
case,
I have not done anything though, Your Honor. I mean, this is against the law.
no, what would be against the law is for me to grant your relief you're requesting. Because they, like you have rights, they have rights. You brought this before the court. And I'm going to say it again to you, so hopefully it'll sink in. They properly got a judgment. Upon properly getting that judgment, they properly requested an order of eviction. I issued the order of eviction. That order of eviction, the judgment, because you have not provided a basis, that will stand. Your motion.
I did nothing after August other than oblige where a month to month was concerned. That was the agreement. I did not refuse payment. There was no probable cause. She put a renewal underneath my door. I says, well, where's the sheet of paper if you're trying to renew? And then she's flip-flopping back and forth with me. Well, I'm like, okay, I thought I was supposed to be on a month to month. That's all it was. She lied to me. And then she lied to me again. And then she tried to take the money out 3 times. So it got me confused. I'm like, well, then am I on a month to month? The bank has that on record. So I came in thinking that if I spoke the truth, because I was sworn in last year and it was agreed upon that I'd be on a month to month after August. That was it. It was as simple as that. I contacted your courts on numerous occasions prior to the end of August.
Ma'am, maybe you don't understand. I just issued my ruling. Your motion is denied. What I will indicate is that the escrow will be held for 15 days and then it will be released back to the defendant. I will not pay the escrow over to the plaintiff. It will be released back to the defendant in this case. Thank you.
So what is the
Thank you,
time
Judge.
frame? May I have till the end of January, sir?
Ma'am, you're operating on borrowed time. I signed the writ
I cannot just
December 3rd. I signed the writ December 3rd.
to have a moving truck in, please, sir. I mean, it is the dead of winter. I have no problem moving out. I've been looking for another place because I don't trust the people. First, they're making an agreement with me and then they're flip-flopping. Could you please, a little courtesy where this is concerned, please?
You've not granted me any courtesy in terms of your talking. Why should I grant you any? But despite that, the writ will not execute prior to January 16th. So I will give you that grace of 10 days, and if I hear anything else, I may take that.
So I have to be out of this place by January 16th?
They cannot execute the writ prior to that date.
Okay,
Because otherwise they could do it tomorrow.
right.
I am giving that 10-day, I'm giving you that period. I'm not giving you to the end of the month. I'm giving you that period. That's as far as I'm going. I'm done.
I don't know what I did, and I feel swindled.
Judge, should I enter a order to that effect or will the court?
Yes, sir. Please.
Okay, thank you. I will
Prepare an
email.
order under the 7-day rule, please.
I'll do that.
Thank
Thank you,
you.
Judge. Have a great day.
You do.